Hi friends, we have a very special personality among us today who is going to give us unique insights in the legal industry. He is a person who has spent 45 years in the practice of law, the one and only Advocate Matthews Nedumpara. Welcome to this discussion, Mr. Nedumpara. So tell us, Advocate Nedumpara, we hear a lot about something called a basic structure theory. Now, from a very layman's point of view, what is this basic structure theory? Our people want to understand.
See, the basic structure theory is a concept which the Supreme Court has. The full court of the Supreme Court in Keshavananda Bharati upheld and held that the Parliament is competent to abrogate every section, every article of the Constitution, but not the basic structure. This principle, this theory was invented primarily to prevent Indira Gandhi from amending the Constitution and taking away the property rights. Now, the theory became quite popular because there was a great political opposition to Indira Gandhi, many of her dictatorial ways. So the basis then since then the Parliament's power to amend the Constitution was considered to be not unlimited, and if a constitutional amendment takes away or abridges the basic structure of the Constitution or basic features of the Constitution, then to that extent that amendment is unconstitutional and void. Now, my concern is, why I am a critic of it, is because of the great prejudice, the great mischief such a concept has caused to the Indian jurisprudence. In the first place, the concept of basic structure is something which is totally alien to jurisprudence. The core or the first principle of jurisprudence, if I am asked, I would say, ibi just ibi remedial. If there is a right, law will provide for a remedy. The concept of right, remedy, form. So the Constitution of India, Article 32 says, any person without recourse to any other forum can straightaway approach the Supreme Court if there is a violation of or the enforcement of fundamental rights. And that right to approach the Supreme Court under Article 32, which is a procedural right, is also termed as a fundamental right. So any person in this country, any citizen, can without recourse to any court alleging violation of fundamental rights. Suppose you have taken in legal custody by the police, or your right freedom of speech or movement, anything is infringed by the state or its instrumentalities, he can straightaway go to the Supreme Court. So this concept, so that the right to approach the Supreme Court as the first court of original jurisdiction, to my knowledge, is nowhere. It is not there anywhere else in the world. And this, so prior to Keshavananda Bharati, people used to go to the Supreme Court for enforcement of their fundamental rights. Then after the Keshavananda Bharati, then the plea is literally none of my fundamental rights are violated. The basic structure is violated. So the Keshavananda Bharati's case said the Parliament is competent to amend every article of the Constitution, abrogate every other article of the Constitution except the basic structure. Now let us assume, if the basic structure, if minus fundamental rights, what is there? So the question is, anyone familiar with the jurisprudence would know, you can go to a court. If you go to a court, the judge would ask you, who are you? What is your grievance? So one can approach a court if his rights and the Article 32, his fundamental rights, are infringed. And after Keshavananda Bharati, all these PAL Valas, they invoked the jurisdiction of the Supreme Court, literally asserting that None of our rights are infringed. Why are we here? None of our rights are infringed. The basic structure is infringed. And this has caused so much of a mischief and calamity that a time has come that we have to have a virtual revolution against the concept of basic structure. The Constitution of India provide for a appointment of judges. Appointment of judges is an executive function, and the President under Article 73 of the Constitution is to act on the aid and advice of the Council of Ministers. And under the Constitution, there is an obligation to consult the Chief Justice of India and such other judges in the case of appointment of judges of the Supreme Court, and in the case of the High Court, the judges of the Chief Justice and the government, that is the state government. So this constitutional provision was abrogated. The constitution was turned into, or it was rewritten in the Judges 2 case. And the ploy they employed there is the concept of basic structure. The logic is this, what they said is, independence of the judiciary is a basic structure. And the core of the independence of judiciary is not the free discharge of the judicial function post-appointment. No. Post-appointment, there are so many protections. A judge cannot be removed except by way of impeachment. His salary and other conditions cannot be changed to his disadvantage. So they said the core of independence of judiciary is not in the discharge of the duty post-appointment, but it is in the appointment. And in then the appointment, that core of independence is protected only when the opinion of the Chief Justice of India is given the primacy. So the Constitution only says the President shall, in consultation with the Chief Justice of India and such other judges. So the word consultation does not mean consultation. Does not even mean concurrence. It means primacy. New concept of judicial primacy. And then the opinion of the Chief Justice of India is not the opinion of the Chief Justice. It is the opinion of the plurality of the judges. And that is how the concept of collegium was established. So it is completely against the Constitution, and a new mechanism which is absolutely the result of a judicial lawmaking law. The judicial lawmaking, which the judges have no power at all. And since 1993, the judges started appointing themselves, and the blood is thicker than water. And whom they appointed all their kith and kin, their juniors, and some people are politically connected. So the entire Constitution was hijacked. And the judges today, I may not be misunderstood, I would say they are not de jure judges, they are de facto judges. There's a difference between de jure and de facto judges. And look here, the calamity today. The national, there's a proposal to, there's an enactment to bring in National Tax Tribunal. Even the National Tribunal Act has been struck down, saying that it is violative of the basic structure of the Constitution. And this concept of basic structure, which has nothing to do with the jurisprudence, is completely alien to the concept of jurisprudence. The entire constitutional law today is based on that. There are thousands and thousands of judgments written, all relying on the basic structure theory, which is absolutely absurd. Nothing else is more laughable than that. And and this is part of the curriculum. Not it is taught in the schools. This absurdity is taught in the schools, and thousands of judgments are written based on this absurdity. And now today, look at that. Rule of law has become supremacy of the judges. Judges can do anything. And see, I am somebody who stands for the liberties of the people. I am somebody who pay the highest regard for the concept of judicial review. Judicial review means if somebody's fundamental legal rights are affected by an unjust law, which the state cannot enact within the framework of the Constitution, the vesting a power in the court to declare that law is unjust. Suppose somebody has to be, tomorrow the parliament makes a law providing that somebody who is alleged to be a terrorist can be hanged without a trial. So such a law has to be declared to be unconstitutional because it violates rights. So judicial review has to be in the realm of preservation of rights.